Hello friends, in the series on the income tax cases, today we will discuss a very important case which is near about 17 years old. The name of the case is PRAKASH, NATH, KHANNA and another versus Commissioner of Income Tax and another. This case has been reported in 266 ITR at page number 1. The matter has been decided by Honorable Supreme Court and the date of the judgment is 16th February 2004. In this case, the very detailed facts are not required to understand the matter. The only fact which is important to tell you is that in this case, the assessee has not filed its return within the due time which is mentioned in section 139 subsection 1. But the assessee has filed the return belatedly which is mentioned in section 139 subsection 4. It is a very common practice between the assessees that generally they do not care about the date of filing the returns, and they think that if the 31st July, if it is in the case of individual, or if it is 30th September in case of companies, if they are not able to file it up to 31st July or 30th September, then they will file it belatedly with some interest up to 31st December. But in this case, the assessee has not filed the return within section 139 subsection 1 but filed the return belatedly, and the department initiated prosecution proceedings against the assessee. It was the point of the assessee that I have filed the return in section 139 subsection 4, so the prosecution proceeding should not be initiated and pursued against me. So on this point, the Supreme Court said that in section 276CC, which says about the prosecution for not filing the return in due time, the court said that in section 276CC it is written that if the assessee does not file the return within the due time which is mentioned in section 139 subsection 1, the assessee can be prosecuted. The court categorically said that in section 276CC there is no mention of section 139 subsection 4. So it cannot be presumed that there is section 139 subsection 4 also. There is a difference between section 139 subsection 1 and there is difference between section 139 subsection 4. There is difference between both the sections. So if the assessee has filed the return beyond the due date which is mentioned in section 139 subsection 4, even then the prosecution against the assessee can be launched. So this case has very serious repercussion because there is another section 278E which says about the presumption of culpable mental state. It will be presumed that the assessee has culpable mental state in not filing the return in due time mentioned in section 139 subsection 1, and the assessee has to prove in the trial that he does not have the culpable mental state. So it is also a very difficult task because once the prosecution will be started, you have to go to the courts and you have to prove that thing, that why and what is the justification for not filing the return in time. It is not an easy job because sometimes it happens that if an assessee is filing the return in a very casual manner for all the years and which is beyond 31st July or 30th September, then even you cannot take the plea that there was some genuine cause because it is your habit. So this habit of not filing the return on time can be very dangerous. Nowadays, some cases are coming when the department is launching the prosecution for not filing the return on time. So if you have any cloud in your mind, if you have any doubt in your mind that you can file the return belatedly under section 139 subsection 4, then in that case very serious repercussion can be there in the form of prosecution, and you have to prove in the court of law that there is absence of culpable mental state on your part, because section 278E is very clear that it will be presumed that in default of section 139 subsection 1, and the prosecution can be very well lodged against you. At the end of this video, once again I am repeating the name of the case. The name of the case is PRAKASH, NATH, KHANNA and another versus Commissioner of Income Tax and another, and this case has been reported in 266 ITR at page number 1. The date of the judgment is 16 February 2004. Thank you friends.